This is TVC News at 7, reaching you live from our headquarters here in Lagos. We begin from the nation's capital, where the Supreme Court has reserved judgment in the appeal filed by the People's Democratic Party, challenging the judgment delivered by the Court of Appeal, which affirmed the election of President Bola Tinubu. The court also reserved judgment in the appeal filed by the Labour Party, saying a date will be communicated to parties when the judgment is ready. Judiciary correspondent Celestine Area reports.
Security at the Supreme Court was beefed up for the hearing of the appeal filed by the PDP, Labour Party and APM. This is the first time the Apex Court will be sitting on the case after the Presidential Election Petitions Court delivered judgment on 6 September 2023. The first appeal taken was that of the PDP, where its counsel Chris Uche told the court that they have an interlocutory application. The application is seeking leave of the court to present fresh evidence. This, they say, is pursuant to Section 1371J of the Constitution. The party and its presidential candidate explained in their affidavits why the evidence was not presented at the lower court. They prayed the court to set technicalities aside and look at the substance of the case. A 7-member panel led by Justice Ian Gukuru, as well as a member of the panel, Justice Emmanuel Augim, posed a series of questions to the PDP. Should the court be guided by the provisions of the Electoral Act or the Constitution, or should the court act arbitrarily? Has the Chicago State University written a letter disclaiming the certificate issued to the president? Why was the deposition of the registrar of the Chicago State University not done before a court that allowed the discovery in the U.S.? Does the stenographer have the legal authority to conduct such depositions? Was there legal authority ordering the deposition to be made in the office of Mr. Atiku's lawyer in the U.S.? How should the evidence be tied? Should pleadings be made and witnesses called? In his response, counsel to the PDP held that the laws in the U.S. is different from that in the Commonwealth region. Pursuant to the U.S. court order, a position was taken in which the president was represented by a counsel. He alleged that the deposition confirmed that the certificate did not emanate from the school. On his part, counsel to INEC prayed the court to dismiss the appeal. Counsel to the president told the court that a counter affidavit has been filed, urging the court to dismiss the application. He noted that the deposition of the registrar of the school is not admissible, as the deposition is dormant until the deponent comes to court to adopt it. Counsel to the APC adopted the submissions of counsel to the president. The court subsequently reserved judgment. The court also reserved judgment on the appeal filed by the Labour Party, saying a date for judgment will be communicated to parties. The court, however, dismissed the appeal filed by the Allied People's Movement for being frivolous. In a unanimous decision, the court held that it is not bound to hear every appeal, as issues raised by the appellant have been resolved by the court. The Supreme Court is not set up for academic exercise. Counsel to the APM subsequently withdrew the appeal, and it was accordingly dismissed. The Chief of Staff to the President, Femi Gbajabiamila, alongside the National Security Advisor Nuhu Rubadu, National Chairman of the APC Abdullahi Ganduje, and the National Secretary of the APC Ajibola Bashiru, were in court to observe the day's proceedings.
Proceedings are very, very challenging because all the contendants who wanted to claim certain issues, they did it very well. And at the same time, those who are defending did it very well. And judgment has been will be fixed later on, but I think we are the winners.
Justice Ian Gukuru noted that it is wrong to file an appeal when the appellant will not benefit from the judgment. He says the appellant ought to have gotten the hint from the judgment delivered by the Supreme Court in the case of the PDP versus the Vice President, where the court settled all issues relating to placeholder or double nomination. Celestina Area, TVC News, Abuja.
For further perspectives on the proceedings at the Supreme Court, I'm being joined on the news by TVC News Judiciary correspondent Celestina Area. Celestina, can you explain to us the distinction now between this judgment that is being reserved and the final judgment in this case?
Okay, well, about today, what was taken today was the interlocutory application filed by the PDP and the main appeal itself. Before proceedings commenced, Justice Ian Eko said that the interlocutory application will be taken alongside the appeal and judgment will be delivered same day for both applications. So what that means is that the day the Supreme Court will announce, according to them, the reserved date, when the judgment is ready, they will communicate the date to parties. On that day, we would hear the Supreme Court's position as to the evidence which the PDP is trying to bring in, which is a fresh evidence, to the application. But we know this particular case has gained a lot of traction. But one thing is clear, whatever is on the social media or in the media has nothing to do with what is before the court. The Supreme Court is not moved by media trial or sentiment. It must decide cases in respect to how it is and not how it ought to be. Although, yes, the counsel to the PDP prayed the court not to look at technicalities, that they should look at the substance of the matter. But technicalities cannot be eroded from proceedings because the court now is questioning the proceedings that led to the deposition and also the certificates which they are seeking to tender before the court. The deposition that the PDP said they carried out with the registrar of the Chicago State University. How was that proceedings conducted? It was not conducted before the court. It was conducted in the office of Atiku's lawyer in the. So now the Supreme Court is saying that is that supposed to be the right place for the deposition to have held? And also the stenographer that was there, does he or she have the legal right to do so? So these were the issues that the Supreme Court raised, posed as a question to Mr. Atiku and his party. Now that of the APM, the court dismissed it because the court had already, the vice president had no case of double nomination or the case of placeholder did not arise. So the APM at this Court of Appeal, which serves as the Presidential Election Petitions Court, the justices of the Court of Appeal told them the same thing, but they insisted on going ahead with the appeal. The court took the appeal, but also dismissed it. But now at the Supreme Court said that they are not set up for academic exercise. They cannot indulge the APM, knowing fully well that they've already decided on this particular subject matter. So they asked the lawyer to withdraw the appeal, and he did so, and they struck it out. So the Labour Party's petition appeal was also taken, and judgment was also reserved. That when judgment is ready, the court will communicate to parties. But we know the court has 60 days to deliver judgment. Judgment at the Court of Appeal was delivered on the 6th of September. So by 6th of November, the Supreme Court also have delivered its judgment.
All right, Celestina, thank you for this update and, of course, the moment-by-moment update on this case since the very beginning. Celestina, for us there in Abuja. Reactions have continued to trail the Supreme Court's reservation of judgment in the 2023 presidential election that gave victory to President Bola Tinubu. Speaking on TVC News program Beyond 100 Days, former Attorney General and Commissioner for Justice in Kwara State, Salman Jawondo, and former chairman of SPIDEL, Mande Ubani, said the fresh evidence brought by the petitioners may not be admissible by the Apex Court.
The only thing that happened is that the Supreme Court called attention of counsel to the feasibility or possibility of doing what they are asking the court to do, having regard to the limitation of time. Because once a matter, for example, the lower court had 180 days to decide the case on the merit, and that includes the kind of evidence we want to adduce. Now that the evidence was not adduced at the lower court, the presiding Justice Okoro, was now asking, is it possible for them to now admit this evidence at this stage when the lower court is no longer in a position to admit and have such evidence? So these are the legal issues that they asked them. And I think that is a point time to the fact that the application is dead on arrival.
The appellate court reviews decision of the lower court. That's what it does. It does not in any way evaluate evidence and begin to take witness evidence or oral evidence, from witnesses and begin to evaluate. That is the primary responsibility of the lower court. Theirs is to review decision that has already been taken. But the moment you are now bringing fresh evidence, then you have to comply with all the rules of fresh evidence, including cross-examination. Would that happen in this case? I don't think so. And it's something that, as I said earlier, the opposition will bring their counter, and the court now will consider it based on issue of justice and equity. We look at it and deliver decision judicially and judiciously. Judicially in accordance with the law, judiciously in accordance with equity and justice. So, and then the fairness of it all. So the court will take into consideration all that. And let's watch and see what the Supreme Court will do when they deliver their ruling.